In this chapter, we're going to talk about entity selection. Your client wants to set up a business and form a business organization. What form will you choose? Will you help your client choose the corporation? Will you recommend the partnership? Or will you recommend the limited liability company? Now, before we move on to the factors you need to consider when giving your advice, let's talk about the partnership. Up till now, we've envisioned one type of partnership, the general partnership, but there are actually three major categories of partnership. There's the general partnership, there is the limited partnership, which is also called the LP, and then there is the limited liability partnership, which is often called the LLP. We'll get into those and the differences between those a little bit later. All right, so what are the factors you and your client need to consider when selecting among the corporation, the partnership, and the limited liability company as the business entity for the business? Well, you have to consider whether the entity will provide limited liability, whether the entity provides the wanted management structure, and what are the tax issues with respect to the entity. Now, the tax issues, we're going to deal with two issues in this course. There's another course in business entity taxation. It's a very good course. If you plan on practicing in this area of law, I highly recommend that you take this course. For our purposes, we want to make sure that you know the basic idea and that you can have a conversation with your client's tax advisors. You may not be able to give tax advice, but you need to understand the issues and you need to be able to communicate with the tax advisor. We're going to talk about income tax and self-employment tax. Now, these considerations, right, limited liability, management structure, and tax issues, you have to know what the default rule is with respect to each of the business organizations. You also need to know what your client wants and what would be best for your client's situation. Let's talk about limited liability. Remember what limited liability means? It means the owners, the equity holders, the residual claimants are not personally liable for the debts of the business. So let's contrast and compare business organizations, business entities that provide limited liability and business entities that do not provide limited liability. Let's talk about business entities where the owners of the business will be personally liable for the debts of the business. So a corporation's shareholders enjoy limited liability. An LLC's members also enjoy limited liability. So a corporation, its owners, its equity holders are called shareholders. An LLC's equity holders are called members. Each of these business entities provides its equity holders with limited liability. Now, remember, you are still liable for your own torts if you are active in the business. So if I'm a shareholder of a corporation, but I'm also active in the business and I am the CEO or the CFO or the truck driver for the business, I am still liable for my own torts. Limited liability does not protect me from that. All right, now let's talk about personal liability. The partners in a partnership are personally liable for the debts of the business. Partners do not enjoy limited liability, but there are two special types of partnership where the partners will enjoy some aspects, either full limited liability or some aspects of limited liability. And these are the LP, the limited partnership, and the LLP, the limited liability partnership. In a little while, we'll talk about the limited partnership and the limited liability partnership in greater detail. Let's talk about the limits on limited liability. Limited liability is not absolute. There are three important provisos. Number one, you are exposed by the amount invested in the business entity. In other words, if you are an equity holder, a member in an LLC, or a shareholder in a corporation, and you invest money into that corporation or LLC, you stand the chance of losing that money. That money is at risk. Secondly, you are personally liable for your own torts if you are active in the management of the business. So if I am a truck driver for my corporation or LLC, and I negligently injure someone while driving the truck, I cannot hide behind the limited liability veil. I will be responsible for my own torts. I will be personally liable for my own torts, even if they were committed in furtherance of the LLC or corporate business. Finally, creditors understand limited liability, and they will often ask the LLC member or the corporate shareholder to guarantee or co-sign the debts of the business. So imagine I go into a bank and I want a loan for my LLC. If the LLC does not have established credit, the bank will say, yes, I will lend you money, but you either have to guarantee or co-sign the loan with the LLC. And through this private ordering mechanism, you give up your limited liability protection. Just for that transaction though, right? It's not like you give it up wholesale, you only give it up for this particular loan. All right, let's talk about the management structure of the different business organization. Who will run the business and affairs of the business organization? Will there be centralized management, or will the owners, the equity holders, directly manage the business and affairs themselves? Let's talk about the default rules for each of the three major business organizations. So the default rules under corporate law is that there is centralized management in the form of a board of directors. The shareholders of the corporation will not directly manage the business of the corporation. The business of the corporation will be managed by and under the supervision of the board of directors. And that means if you want your client, a shareholder in the corporation, to have an active role in the management of the corporation, you have to make sure that your client gets a seat on the board of directors. And later we'll talk about how to do that. Now, the board of directors is a board. It is also really not directly managing the day-to-day operations of the corporation. And so the board of directors will appoint executive officers. And once again, if you want your client, the client shareholder in a corporation, to have direct day-to-day management, you have to make sure that your client is one of the executive officers of the corporation. And we'll talk about how to do that. The LLC default is that there is direct management by members. And because this is a default rule, you can change it. There's a way for you to get centralized management in the LLC if you so elect. But the default rule, if you don't choose otherwise, is direct management of the members. The LLC, by default, will not have a board of directors and will not have executive officers. You can create those bodies if you want, but by default, the members of the LLC will directly manage the business and affairs of the LLC. Finally, the partnership is like the LLC. The partners will directly manage the business and affairs of the partnership. If you want to have some sort of board of directors and executive officers like you have in the corporation, you can set up the partnership that way. Otherwise, the default rule is that the partners will directly manage the business and affairs of the partnership. All right, let's start our discussion of tax by introducing the idea of income tax, specifically how income tax affects business entities. There are two types of taxation. There's double taxation and pass-through taxation. Pass-through taxation is also often called flow-through taxation. So you'll want to remember those three terms, two different concepts, double taxation and pass-through taxation, but pass-through taxation can also be called flow-through taxation. Well, what is double taxation? Well, double taxation is where the business entity pays income tax on its profits. And then the owners will pay any tax on distributions that they receive of those profits. So when we get into it, we'll give some examples. But there are two levels of taxation, two levels of income tax taxation in the double taxation paradigm. The business entity pays tax and the owners pay tax. Now, there's another paradigm. It's called pass-through taxation. And in pass-through taxation, we don't have that first level of taxation. In pass-through taxation, the business entity pays no tax on its profits. Okay? The profits pass through to the owners, and the owners will pay income tax on the business entity's profits. So double taxation, we have two levels of taxation, taxation at the business entity level and taxation at the owner level. In pass-through taxation, we only have one level of taxation, and that is at the owner level. Let's cut to the quick. A corporation by default has double taxation. We'll talk about ways how you can get pass-through taxation for your client's corporation if that's what your client desires. The LLC, as a default, has pass-through taxation, but we'll talk about ways that your client can achieve double taxation if your client wishes using the LLC. And finally, the partnership as a default has pass-through taxation, but we will talk about ways where you can get double taxation for your client if your client selects a partnership. And you might say, why would I want double taxation on profits? And the answer is that in certain situations, depending on tax rates, double taxation might actually be better for your client.